Hello, I'm Rod Sims, Chair of the Australian Competition and Consumer Commission. I'm delighted to have the opportunity to speak about ex-ante regulation in digital markets. Ex-ante regulation is something I have thought about deeply over the course of my career, and it's great to see the OECD elevating the discussion of its application to digital markets at this critical time. And it is a critical time. Large digital businesses have created innovative services and products which have proven invaluable for people and businesses alike. But their market power has also created many challenges for competition agencies and policymakers in delivering on their mandate to both protect consumers and competition and also foster innovation. Across the globe, we are having discussions about whether our existing, essentially ex-post enforcement tools are suited to the digital economy, which is of course characterised by dynamism, complex technological issues and issues of scale and scope. This is now starting to evolve into the development of novel and far-reaching regulatory proposals in several jurisdictions. Alignment across different regimes is vital given the global reach of major digital platforms. Alignment will provide regulatory certainty to all stakeholders and will help ensure consumers and businesses benefit from regulation to improve competition and innovation in all their markets. While I'm speaking mainly from a competition agency's perspective here, I recognise that digital markets often bring into focus issues at the intersection of competition, consumer protection and data privacy. Therefore, any competition solutions need to consider and be aware of the differing enforcement and policy goals that exist across regulatory frameworks. In Australia, we have taken a comprehensive, methodical approach to understanding the impact of digital platforms on our market economy. The ACCC has been tasked by the Commonwealth's government to undertake a suite of inquiries into digital platform markets over the 5 years until 2025. The mandate we have been given through the terms of reference for these inquiries is to look past the surface level question whether there is a breach of existing law and instead focus on the underlying factors affecting competition and market outcomes. This has allowed us to look deeply into digital platform markets and provided valuable insights about what is happening, including competition and consumer harms. This has subsequently allowed us to consider regulatory interventions that keep competition and sound market principles at their core. As a multifunction regulator with not only competition and consumer regulatory and enforcement roles, but also infrastructure and industry monitoring roles across many sectors, we can speak from experience about the potential for well-designed regulatory regimes to restore competitive balance where competition laws alone are not effective. As an economic regulator, for example, the ACCC oversees regimes that facilitate access to natural monopoly infrastructure. This allows for any privately owned infrastructure facility that exists within a supply chain to become what is known as a declared service. This is unique among comparable jurisdictions. The key feature of this regime is that once a service is declared, firms have a right to negotiate access to the declared infrastructure assets with an arbitration mechanism available when these negotiations break down. The ACCC also oversees several mandatory industry codes of conduct. These codes, developed by the government, set out minimum obligations and standards of commercial conduct for industry participants. They can address industry-specific market failures that have not otherwise been addressed by industry participants or by other regulation, but that nonetheless undermine the competitive process, leading to inefficient market outcomes and a loss of welfare for the public. I highlight these two vastly different but effective regulatory regimes to demonstrate the variety of approaches that are already possible in Australia to address market failures outside of enforcing traditional competition laws. A further example of a regulatory approach in digital markets, which the ACCC led, is the News Media Bargaining Code. In the Digital Platforms Inquiry final report, we found that both Google and Facebook were unavoidable trading partners for a large proportion of Australian news media businesses. We also found that no individual Australian news business is as important to these platforms as each of these platforms are to an individual Australian news business. Therefore, both companies, Facebook and Google, have substantial bargaining power in their dealings with individual Australian news media businesses. While bargaining power imbalances exist in many other sectors, the ACCC considered that regulatory intervention was appropriate because of the important benefits associated with public interest journalism. A failure to address this bargaining power imbalance threatened the sustainability of a strong, independent and diverse news media landscape, which is essential to a well-functioning democracy. The Australian Government accepted the ACCC's recommendation in late 2019 and in early 2020 instructed the ACCC to work with government departments to develop a mandatory code of conduct. In March 2021, legislation enacting the code came into effect. The code creates incentives for the major digital platforms to make commercial deals with Australian news businesses by providing a framework for good faith negotiations and a fair and balanced arbitration process to resolve outstanding disputes. Its main features include a requirement for parties to negotiate in good faith bargaining, a mandatory arbitration mechanism for when parties cannot reach a negotiated agreement about remuneration, and non-differentiation requirements for designated platforms, which in essence aim to prevent the platforms demanding news media businesses agree to provide their content for zero cost or relying solely on international news sources and blocking Australian news sources. There are serious financial penalties for failure to comply with the Code's central provisions. While no platforms have yet been designated, the practical effect of the Code has been to encourage Facebook and Google to make voluntary commercial content deals with a wide range of Australian news businesses so as to avoid designation by the Treasurer. So the Code has been a complete success. The Code is an example of how targeted regulatory mechanisms can help address some of the challenges we are facing in digital markets that are leading to adverse outcomes, but may not explicitly breach our current competition and consumer protection laws. It also demonstrates, as I said earlier, the potential value of broad market inquiries in identifying issues and proposing solutions that do not rely on traditional tools of competition enforcement. As part of our digital platform related market inquiries, we are considering whether there is a need for potential regulatory measures to deal with the competition and consumer protection issues we have observed to date. For example, in the final AdTech report, published in October 2021, we concluded that the current competition and consumer law framework was not sufficient to deal with the problems we were observing in the AdTech supply chain, where there is entrenched market power. In order to address these concerns, we recommended that the ACCC be given the power to develop sector-specific rules to apply to those providers of AdTech services that meet predefined criteria linked to their market power and/or strategic position. This followed an 18-month inquiry into the AdTech supply chain, and we set out in detail in that report the rules we'd like to apply to the specific concerns we identified. We also recognise that AdTech specific rules could form part of a broader regulatory framework covering apps, search and other digital platform services where similar concerns arise. We've learnt from all these inquiries that you cannot simply make quick judgments on reform proposals. We continue to undertake rigorous analysis of the domestic and international factors at play across various digital platform markets, and this is allowing us to make appropriate evidence-based recommendations for regulatory reform. While we have so far stopped short of recommending the adoption of frameworks we are seeing overseas, such as those being proposed in the UK and the EU, we expect to be able to provide detailed views on potential sector-specific reform next year in the 5th interim report of this inquiry, due in September next year. Our experience as a competition enforcement agency has shown us how valuable it is to work with our international colleagues and reach coherent outcomes when matters transcend national borders, such as when we are able to work with our international counterparts to consider a merger. Digital platforms have been on the Competition Committee agenda for several years. The discussions we've had have been incredibly valuable in understanding the issues we are facing, as jurisdictions individually are starting to consider whether they have the right tools. Competition agencies and government policy leaders need to explore the options. The OECD is a vital forum to have these discussions and to consider possible regulatory frameworks. I'm greatly looking forward to this discussion. Thank you very much.